Your neighbor's oak roots just buckled your driveway into a jagged ridge of concrete. And here's the part that's going to make you mad. You probably owe the bill. Not them. You. I know how that sounds. The tree isn't yours. You didn't plant it. You didn't water it. It's standing 2 feet over the fence on their property, leaves swaying in the breeze. And somehow its roots crawled under your driveway and turned your concrete into a skateboard ramp. So obviously, they pay, right? Stick with me. By the end of this, you'll know exactly who pays for root damage, when the neighbor actually gets stuck with it, and the one written move that flips this whole thing in your favor before the cracking even starts. This is the dispute. 2 neighbors glaring across a fence, one towering tree between them, and a ruling that surprises almost everybody. Let's go. Picture the moment. It's Saturday morning, coffee mug in hand. You walk out to grab the mail, and your foot catches on something that wasn't there last month. You look down. Your driveway has a ridge in it. The concrete is lifting, like something underneath is pushing up to get out. You crouch. Your finger traces the crack. It runs straight back toward the fence. And there, poking through the dirt at the edge of your property, is a root, thick as your wrist, coming from the big oak next door. You stand up, already rehearsing the speech in your head. You picture yourself knocking on their door, polite but firm, arms crossed. Their tree, their roots, their problem. And the neighbor, let's call him Dave, opens the door, glances at your driveway, glances back at his tree, and says something like, "Yeah, that's rough. But that's not really my tree's fault, is it? Because the law doesn't care who planted the tree the way you think it does." Let me build this from scratch. Imagine a green garden hose snaked across your yard, and it slowly creeps under the fence into your neighbor's grass. Once that hose is on their side, physically lying on their lawn, they're allowed to deal with it. They can move it. They can cut the part on their side. It's in their space now, so it's their call. The law treats tree roots crossing the property line almost exactly like that hose. This is called the self-help doctrine, and it's one of the oldest, weirdest rules in dusty property law books. Here's what it actually means. Once those roots cross the property line onto your land, you have the right to cut them, right back to the line. You don't need permission. You don't need a judge in a robe. You don't even need to tell Dave. Sounds great, like you just won, fist in the air. But read the fine print, because here's the part nobody mentions at the door. You can cut them at your own expense, wallet open. That's the trap. The same rule that hands you the saw is the rule that makes them your problem. The law basically says, it's on your land, so it's your job. Grab a saw. So yes, Dave's tree, your roots, your bill stamped paid by you. Completely legal, completely infuriating. Also, and write this down, completely avoidable, if you know what's coming next. Now you're probably yelling at your screen. How is that fair? It's his tree. But fair and legal are 2 roommates glaring at each other across a messy kitchen. Here's why the law set it up this way. If every homeowner could mail a bill next door every time a root wandered over, the courthouse would drown in paper. Every leaf, every branch, every root, a lawsuit. So the law drew a clean line. Literally, the property line. Your side, your call, your cost. For a single leaf that blows over, that's reasonable. For a $4,000 driveway estimate, it stings. So is that it? Are you just stuck writing a check for a tree you never wanted? No. And this is the turn, because there's a crack in the self-help rule. Pun fully intended. And it's where most people win this fight without ever noticing the door was open. The magic word glowing on the page is neglige. Me make that real. Negligence isn't some fancy courtroom term echoing off marble walls. It just means somebody knew about a danger, could have fixed it, and did nothing. Picture a homeowner with a dog that already bit 3 people. First bite, maybe an accident. But once you know your dog bites, and you let it roam the sidewalk anyway, now you're responsible. Because you knew. Trees work the same way. A healthy tree dropping normal roots into the soil, that's just nature. The self-help rule wins. You pay. But a tree that Dave knew was diseased, dying, or aggressively buckling everything around it, and he just let it stand there after you told him? That's the biting dog. That's the moment the bill can swing back across the fence to Dave. Here's the part that genuinely sounds made up. The exact same root damage can be your problem or his problem, and the deciding factor isn't the tree at all. It's a single piece of paper, whether you wrote it down. Because liability here isn't decided by whose tree it is. It's decided by who knew about the risk and what they did after they knew. And knew only counts if you can prove it. If you walked over, mentioned it casually, Dave nodded, and nothing changed. Legally, that conversation evaporated into thin air. There's no proof. It's your word against his, and I think I told him once is not evidence. It's a fuzzy memory. So let's talk about the verdict and the move. The verdict? In most states, if a healthy tree's roots damage your driveway, you pay. The self-help rule rules the day. Harsh, but that's the default stamped on the case. But if you can prove the neighbor knew the tree was a hazard, diseased, leaning, clearly destructive, and ignored it after you put them on notice, now negligence kicks in, and that bill can land squarely on his doorstep. The whole case turns on one thing. Did you create a paper trail before the damage got bad? So here's exactly what you do tomorrow morning. Step 1. Document the tree now before there's serious damage. Phone photos of the roots. Photos of any hairline cracks starting. Date everything. Your phone stamps the date automatically. That little timestamped is your friend here. Step 2. If the tree looks sick, leaning, or like it's actively wrecking your property, get it in writing to your neighbor. Not a text you'll lose, not a shout over the fence, a real dated letter on paper. And keep it boring. Something like, "Hi Dave, I've noticed your oak's roots appear to be damaging my driveway, and the tree looks unhealthy on my side. I wanted to make you aware in case it needs attention." Polite, factual, devastating in court. Why does that letter matter so much? Because it does one thing. It starts a ticking clock on what Dave knows. The day he reads it, he can't say, "I had no idea." You took away his best excuse. In writing, with a date. Step 3, send it so there's a record. Certified mail with a signature or email. Anything that proves it left your hands and landed in his. That letter is the difference between your problem and his problem. Same tree, same roots, same cracked concrete. One piece of paper decides who pays. Now, the one thing you must not do. Do not march onto Dave's lawn and start sawing the roots on his side. The self-help rule only protects you up to the property line. Your land, your saw. Cross that line and start hacking. and you can be the one on the hook for harming his tree. People have paid thousands for killing a neighbor's tree they were trying to fix. So cut to the line. Never past it. And one more thing, because this genuinely matters, these rules shift from state to state across the map. Some states lean harder toward your problem. A few are friendlier to the damaged neighbor. So before you do anything big, pull up your own state's rule on root encroachment. 5 minutes of searching can save you a driveway. Here's the truth nobody tells you at the property line. The law isn't on the side of whoever's right. It's on the side of whoever wrote it down. Dave isn't confused about his tree. He's betting you never put it in writing, because the second you do, his free pass disappears. So here's my question for you. Should the law really make you pay for a tree you never planted, never wanted, and can't even touch on his side of the fence? Or is the self-help rule actually fair and we just don't like hearing it? Tell me who you think should pay. I'll read the arguments.